Hello everyone, welcome back to the channel and to another quick take. The first that pertains to Johnny Depp and the upcoming trial in Virginia. So a few days ago, the judge denied both of Johnny's motions. Now, these motions were in relation to the anti-slap immunity that Amber is depending on as a defense, and count 2 of Amber's counterclaim, which is defamation and defamation per se. Now, from the get-go, I do want to say that there is a lot of presumed knowledge in these videos. So for those of you who've been around for the last 2 years, there is an expectation that you know the background, because if I'm going to rehash Amber's counterclaim and her anti-slap defense, it's just going to be repetition, and it's nothing new that you haven't heard before. So just bear in mind. Now, before I discuss why I think the judge denied both motions, because I actually don't know, so it's just an educated guess, we're going to briefly look at what these motions entailed. So starting off with the anti-slap immunity motion. So Johnny basically applied for summary judgment, which means that he wanted the court to declare or to pass judgment without going to trial that Amber cannot rely on anti-slap immunity as a defense. Now, to understand Johnny's argument, we must revisit very briefly Virginia's anti-slap statute, which I'm sure is very familiar to all of you who've been following for the last couple of years. So specifically, the section reads, "A person shall be immune for a claim of defamation based solely on statements regarding matters of public concern that would be protected under the First Amendment." And more importantly, and it's not here on the screen, but I do remember this from covering it so extensively, it only kicks in the absence of actual malice. So if it is found that the defendant acted with actual malice, then this defense, regardless of the fact that it was made regarding matters of public concern, does not apply. So basically, you can see here on the screen that they're arguing that Amber's statements in the op-ed were in relation to what allegedly occurred in her private domestic relationship with Mr. Depp, which to them doesn't fall under the definition of a matter of public concern, which here has been defined by case law as a matter of political, social, or other concern to the community, as opposed to a matter of only interest. So what they're arguing here is that Amber Heard didn't just simply make statements about DV in a very general sense. She particularly named him, well, she didn't in the op-ed, but, it was found by the court a couple of years ago that defamation by implication is a very viable possibility, at least enough to progress to trial and have a jury decide whether it occurred or not. So in essence, and again, as you can see here, he is suing her for publicly naming him and forever tarnishing his good name. An act that, coming from an ex-spouse, is fundamentally personal in nature. So the gist is that she made those statements targeting a single person, being Johnny in this case, rather than a generalized statement. Now, they go further and argue that you must consider the context rather than just viewing the op-ed as an isolated incident, because they argue that it's not. And by this, they mean Amber didn't just write the op-ed and, otherwise left Johnny alone. She has been publicly behaving in a way, and this is their argument, that would purposely paint the picture in people's minds that Johnny committed DV. And an example of this that they reference is when she went to court on the 27th of May of 2016 with bruises on her face, in full view of the press, as you can see here, to obtain a DV restraining order. So there's a background to this op-ed, a background that clearly links Johnny Depp to her allegations of DV. And so that concludes their submissions, which, as we know now, were denied. Now, moving on to Amber's response, Amber Heard's opposition for summary judgment. So, interestingly, by the way, they even point out in this response that Johnny is seeking, or rather, Johnny sought summary judgment based on the first element of the anti-SLAPP statute. So he's disputing the fact that it was a matter of public concern rather than focusing on the second element, which is that this defense doesn't apply if there is actual malice. The court probably would have ruled that it's for the jury to decide whether actual malice was actually present as an element or satisfied as an element. So it would have failed anyway, is what I'm trying to say. Now, just in summary, Amber's team argues that it is in fact a matter of public concern, and simply using your personal experiences does not automatically negate the fact that a particular statement is still in relation to matters of public concern. This reminds me of qualified privilege here in Australia, where you are protected from you can use it as a defense if you discuss matters that, amongst other things, can be viewed as matters of public concern as long as there's no malice. So it's very similar to the Virginia anti-SLAPP statute. So honestly, I see what they're saying, but the issue is, again, context. Now, they're arguing that the court should completely disregard Amber's actions in 2016 in terms of, going to court, parading herself in front of the press, because that's not what Johnny's suing her for. He's only suing her for the op-ed. As you can see here in this paragraph, Mr. Depp argues that Ms. Heard's conduct from 2016 to the time of the op-ed somehow exempts application of the anti-SLAPP statute, yet Mr. Depp's complaint is based solely on the op-ed and no other activities. I will say at the end of the day, since the court did deny Johnny's motion, this is what I think happened in relation to the anti-SLAPP summary judgment motion. I think that the judge decided that there is enough for the jury to make up their mind on this issue. There's enough for the jury to decide whether it was a matter of public concern or not, and whether actual malice was involved or not. So basically, it would be ultimately up to them as the trier of fact to arrive at a decision. Again, I don't have access to the judge's reasons, but that's my educated guess. Now, the next one is a little bit messier because it involves Adam Waldman's statements that survived demur 2 years ago. All right, so we'll start off with Johnny's memorandum of law in support of plaintiff's motion for a summary judgment regarding counterclaim of Amber Heard. Now, if you'll remember, I believe 3 statements survived demur, and all 3 of these statements were made by Adam Waldman, not Johnny Depp himself. Now, this isn't the first time Johnny's tried to challenge these statements because, as I said, they survived demur, which means Johnny objected to them in the first place. And I covered it extensively in 2020. But yeah, Johnny has already argued that you're suing the wrong person here. And the prior judge found that these 3 statements can proceed. And it looks like this judge agrees. But a lot of the arguments relied upon here are very similar to Johnny's initial demur. So firstly, they start off by saying that Amber has no evidence of direct liability. So basically, they're saying that there is no evidence of any communication between Johnny or Mr. Waldman regarding the 3 statements that were made by Mr. Waldman. Now, as the counterclaim plaintiff, the burden does rest on Amber to prove that Mr. Waldman acted as Johnny's agent. Because if you'll remember when we covered this over a year ago now, that's what this ultimately rests upon. The relationship of agency, principal and agent. So in this instance, Johnny would be the principal and Adam Waldman his agent because he was acting as his lawyer and Amber's side is arguing while he was carrying out the duties that he was authorized to carry out by Johnny, whether implicitly or explicitly authorized, by the way. You don't have to have an explicit authorization, but so in some cases it can be implied. Now, Amber's going to have to prove that whether implicitly or explicitly, Mr. Waldman acted as Johnny's agent. That is the only way that Johnny can be liable for Mr. Waldman's actions. Now, unfortunately, the 3 statements that survived demurrer were, I believe, all made to the press rather than Mr. Waldman's Twitter account. Because if it was his Twitter account, which I think maybe some of them were, but they never survived demurrer because of the statute of limitations. I don't remember actually, but in any case, it would have been easier to argue that this is his personal Twitter account. You know, Johnny has no control over what he says in his personal Twitter account. But these were made to the press. Now, I already said that it's incredibly common for lawyers to make comments to the press about the case that they're involved in. And at the time, Mr. Waldman was actually acting for Johnny in Virginia. He no longer is, as far as I know. But when he made them, he was. And so he was merely, in my opinion, repeating their side or their submissions or their arguments to the press. You know, throughout Johnny's complaints, he has stated that Amber Heard is orchestrating a hoax to bring him down. And that's pretty much what Adam Waldman has repeated to the press. So it's nothing that people didn't already know. These documents, as you can see right now, are available publicly. We all know what Johnny's legal stance is, what his argument is. So it is important to note that Johnny's team has stated that Amber has yet to prove or provide evidence, rather, of Johnny directing Adam to make these statements. But again, since this motion was denied, we can probably guess that the court believes that she could be able to prove it during trial. Secondly, they argue that Amber can't prove actual malice, which, because she's a public figure, is an integral element that must be proven. So you'll all remember that to private individuals, the standard is negligence, but in this instance with public individuals, it's actual malice. So they're arguing that in order for Adam Waldman to even be liable, or rather Johnny to be liable for defamation, Adam Waldman must have acted with actual malice in making these statements. And that's what I mean when I say he was repeating Johnny's legal arguments. You know, with actual malice, it's more you are full on lying to the press, for example, without any reasonable basis. You know, you're making these statements to tarnish someone else's reputation without any other basis. But in this instance, there is a basis. He is stating his client's stance. So here I think, and again, unfortunately, it did not succeed, but I think that, and when I say unfortunately, it's not that bad. Basically, Johnny's team can now rely on these arguments in trial. So it's not like it's the end of the line when it comes to defeating Amber's counterclaim and her anti-SLAPP immunity for that matter. They just have to argue whatever they've argued in these submissions for summary judgment at trial in front of the jury. So they state that there is no evidence that Mr. Waldman knew that his statements were false, because that's what actual malice is. It's a much higher standard than negligence. You have to knowingly make statements that are either false or you had a reckless disregard for the truth. You couldn't care less whether what you were saying was substantiated or not. They go on to say, nor is there any evidence in the record that Mr. Waldman subjectively entertained serious doubts about the falsity of the counterclaim statements. Again, there's no evidence that he acted with a reckless disregard for the truth. They also argue that they are expressions of opinion and are therefore protected under the First Amendment. So they say that any reporter or reasonable reader would understand and expect a lawyer that is acting for Johnny Depp to challenge Amber's version of the story. It's only natural. That's the nature of litigation in this instance. And they're saying that the context of a lawyer commenting on his client's submissions or his client's stance necessarily negates any suggestion that the statements are properly understood as objective statements of fact. So this is merely the lawyer's opinion of his client's case. Mr. Waldman's opinions are not presented as a definitive version of events or as statements of a percipient witness, but as mere advocacy, one side of a fiercely contested story as characterized by a lawyer, where it is clear from context and the content of the statements that the facts are contested. Again, this is really a repetition of that main gist. This is a lawyer commenting on his client's case. He's not saying anything new. He's not hitting, below the belt. He's repeating his client's statements, allegations, and everything else that is contained within his client's complaint. And that's pretty much it. Now, of course, we will look at Amber's response to this. And let's see how much time we have. It's getting a bit long, but Johnny does also respond to Amber's response. So let's see if we can do this a little bit quickly. And again, this is nothing new. When Johnny submitted his demurrer 2 years ago, Amber did reply to that and argue why Johnny is liable for Mr. Waldman's statement. So this is more of a refresher. Now they're arguing that agency can be inferred, so they don't have to explicitly prove it. Direct evidence is not indispensable. Indeed, frequently it is not available. In this instance, for example, it would be hard, or at least there is the client-attorney privilege aspect. So communications between Johnny and Adam Waldman are inherently protected as a result of this privilege unless it was waived. So sometimes it is impossible or difficult to obtain this evidence. Also, imagine if, for example, a principal instructed their agent verbally. It wasn't recorded. There's no actual evidence of that communication taking place. So again, it would be unavailable to the other side to prove that the principal authorized or even directed the agent to act in a certain way. And so that's why they're saying sometimes it's all circumstantial. You infer based on the nature of the relationship. So for example, again, Adam Waldman being Johnny's lawyer. So they're arguing that the question of agency and whether it existed or not is a fact that is ultimately for a jury to decide. Now, they also argue that actual malice is a question for the jury. So again, it links back to my educated guess of why this will proceed to trial, because objectively, I can understand how this is a matter for the jury to decide. And it's a matter for Amber to prove agency and a jury to figure out whether they buy the story or not, or whether there is enough evidence to prove agency, or whether there isn't. Now, with regards to actual malice, they're arguing that Johnny knows that his allegations of a hoax are false. And so they're arguing that they did indeed act with actual malice, or he acted with actual malice because he knows they're false. Now, again, I believe this is a matter for the jury to decide. You can't just simply state that Johnny knows that his allegations are false. This is up to the trier of fact to decide on that issue. Now, they're using attorney-client privilege against them. So both Johnny and Mr. Waldman relied on attorney-client privilege to refuse to answer questions pertaining to these statements. And so Amber's team are saying that given Mr. Waldman's and Mr. Depp's refusal to answer these questions based on attorney-client privilege, it must be inferred that Mr. Depp was involved in the statements. Otherwise, there would be no privilege attached. This is the fairest and most logical inference, since Mr. Waldman admitted making the statements, he was Mr. Depp's lawyer, and all three statements identify Mr. Waldman as Mr. Depp's lawyer. Given that Mr. Depp knows these statements are false, actual malice has been shown. Now, they also argue that they're not opinions, these statements. And by the way, I don't know if I mentioned earlier, but in the demurrer stage, they were characterized as opinions and the court disagreed, which is why they survived demurrer and are now part of the counterclaim. So they're arguing that they're not statements of opinion because they are capable of being proven to be either true or false, which if you'll if you watched my previous videos over the last 2 years, you would know that that is an integral element of defamation. It must be a statement of fact. And how can you determine whether it's a statement of fact or opinion? A statement of fact can basically objectively be proven to be true or false, rather than an opinion about someone or something. They're using examples that the statements went beyond opinion and accused Amber of committing perjury and fabricating evidence of DV, etc., characterizing it as a hoax. All of these allegations can be proven false and therefore cannot be opinion. So for those reasons, they state that this summary judgment must be denied. And before we end this video, we'll quickly have a look at Johnny's, is this the response? No, this is the reply. They're basically repeating the fact that they are non-actionable opinions. Specifically, they say his statements are presented as the analysis of a partisan attorney with a disclosed bias. Of course, that disclosed bias being that I am Johnny Depp's attorney. I act for Johnny Depp. Drawing conclusions from developments described in the article, Mr. Waldman nowhere claims to be a fact witness or to have direct personal knowledge. And Mr. Waldman's statements are flatly contradicted in each article by the opposing side. So it wasn't a one-sided story. Both sides were presented in these articles. So in context, any reasonable reader would interpret his statements as subjective opinion and partisan advocacy. I would lean more towards partisan advocacy rather than subjective opinion on a case. And basically, look, as I'm reading through this again, it's a repetition of the initial motion for summary judgment. So everything we discussed in the motion, the one that we discussed earlier, is pretty much repeated here. So that concludes this video. At the end of the day, as I mentioned just a few minutes ago, I'm not necessarily confident with the opinion argument, and the fact that it's been shot down once already 2 years ago, it makes you lean towards the fact that it's probably a weak argument because now it's been shot down a second time. At the end of the day, as I said also earlier, this isn't the end of the line for Johnny in relation to these arguments. But now the situation is, rather than get rid of them before the trial starts, he's going to have to shoot them down during the trial. So yes, it's more effort, more time, and more heartache, more stress, more work. But yeah, I can't believe we're incredibly close. We're incredibly close. I mean, even here on the Fairfax County website, this is new-ish. It's information for people and the media, spectators and the media who would like to come and watch the proceedings. So if anyone's going, make sure you go check out the instructions. It's about security clearance and whatnot. But yeah, this means that this case is upon us. This trial is upon us. And it has been a long time coming. I don't have a gut instinct. I mean, if I really had to be honest, I don't feel too great about this. But it might be, my perception might be might be influenced by the UK judgment, because that turned out pretty badly for Johnny. Now, the key difference is that there's a jury in this instance, so it's not up to one judge. We're still in the midst of the Me Too era, of believe all women. Not believe all victims, because in my opinion, Johnny Depp is the victim in this instance. Well, based on the evidence available to me, based on what I've seen. At the end of the day, we weren't there. We have to make that clear. But it's the reason I took on this case so wholeheartedly 2 years ago. It's my gut feeling. So what concerns me is we're still not there as a society. We still don't accept that men can be, I was going to say males, and then men can be victimized by female perpetrators. I hope we get there one day. I think we are. I think we will, rather. I think we're moving in that direction. But it's slow. Fingers crossed, that's all I can say. All the best to Johnny. Yeah. All right. Take care, everyone. And I'll see you in the next one.